Good morning, ladies and gentlemen. It's my immense pleasure to welcome you all to today's highly anticipated session on Introduction to Intellectual Property Rights and Patent Filing Procedure in India. We are honored to have our distinguished speaker, respected Dr. Debajit Borah, sir, join us today. Our honored speaker is a highly accomplished individual who brings a wealth of knowledge and practical experience in the field of intellectual property. With over 12 years of teaching and research experience with more than 50 research papers and authored 2 books, he filed 5 Indian patents, out of which 3 were already granted now. He handled 4 extramurally funded projects from DBT, DST, SERB and UGC worth more than 80 lakh and was awarded by various agencies in India and abroad. Most notably, he was awarded with India Exposition Award 2020 by DBT Barak and second prize in Assam Biotech Conclave 2017 by IIT Guwahati and Government of Assam. With such an accomplished background, we are incredibly fortunate to have respected Dr. Debajit Borah, sir, here today to share his personal experience and insights. So let's give him a warm round of applause for the remarkable achievements and for graciously sharing their knowledge with us today. Moving forward, I would like to request respected Soumitra Sen, sir, to come forward and felicitate our respected speaker of the day. Now, please, sir, who will be delivering welcoming remarks today?
We are very fortunate that we have among us Dr. Debajit Borah, luminary in the field of intellectual property rights, patent, copyright, trademark, you name it. At the age of 30 plus, he's got 50 publications. At the age of 51, I got 11. Anyways, there's always a beginning, I guess. Please understand, today morning I was meeting a few students and I was having a class with them, and I was pretty excited about this seminar because you get to learn a lot. So I happened to ask some of the students, what is the topic and all. Like before, like how Dr. Soumitra Sen said on the previous day when Trip Nadi came, so there were people who are a little not too bothered. Please understand, I guess most of you guys have come here to get a degree, okay? Very few people have come here to learn. Okay, but I guess everybody need not be successful. Okay, I'm sure all of you will get a job, all of you will get food to eat, all of you will have your lifestyles, but very few people will learn and do cherish and do something well in life. In fact, IPR, International Property, what is it? Property rights. I'm sure you know what your rights are. Okay, but apart from that, in fact, when I was discussing with our resource person, he was telling us, sir, do you eat chips, Lays? Yeah. The way L is written down and every morsel of the chips, it has a pattern, everything has been patented so that nobody else can copy. Okay. It is not only meant for academicians only to publish books and find out new facts and patent it. It is also meant for a lot of people, normal people, could be housewives, could be businessmen, could be anybody. In fact, the other day I was reading, a note. In fact, I saw a video. There was this engineer from NIT, Silchar. He was working with some big company, and after that, he started making Momo machines. I'm sure you've heard about that. So he's patented, and today is about 25 crore turnover business. Okay. So, small things can make a lot of difference in your life. And most of you guys on the fag end of your academic career, either in the UG last semester and PG last semester, it's time to introspect and do something worthwhile. Please have all the fun, because this fun will never come back to your life. But apart from fun, academics is equally very important. Okay. Anyways, I can go on and on. Okay. So I guess, sir, from your valuable insights, we'll learn a lot. And my dear students, if you have any kind of questions, please feel to ask. Questions can be any form. Okay, you don't have to write a question to ask. Anything you don't understand, we can ask questions. So once again, thank you so
much, sir, for initiating this event with such a captivating and inspiring speech. To be inspired and enlightened by their expertise in the world of intellectual property rights and patent filing in India.
Faculty members and my dear students, the topic of this presentation is Introduction to Intellectual Property Rights and Patent Filing Procedure in India, a personal experience. So, at your age, I used to find this topic very boring, even though it was a very important topic, but I used to find it very boring. So, I tried my best to make the slides very interesting for you guys. So, I hope by the end of the session, you will be having lots of questions on this topic and you will really enjoy learning intellectual property right. So, before we begin with intellectual property, you need to understand what is property. Property means whatever you have with you, whatever you own is your property. Say for example, the furniture is the property of the university. Then you have your pen and pencil, whatever you have, whatever you own is your own property. So, you can divide property into two groups. One is known as tangible property and the other group is known as intangible property. That means the property which have physical value and which can be destroyed is known as tangible property. You have cash, furniture, vehicle, building, land property, equipment, anything. So, these are all tangible property, you can destroy them. And you have certain properties which we call as intangible property, which may not have physical existence. It may be there in your mind. It may be protected by the existing lawsuit of the country also. So, these are the patents, logo, copyright, brand value, self-developed softwares, trademarks, etc. I will discuss on all these things in my later slides. So, what is intellectual property right? First of all, what is intellectual? The literal meaning of intellectual is your mind. To use your mind, your creativity, your imagination to create something. So, that is your intellectual property. And who is going to give you the right? So, the existing lawsuit of the country, we call it states. There is a difference between state and government. Government may change. State means the existing rules and regulation. So, existing rules and regulation gives you certain rights to protect your innovation. Your intellectual innovation can be protected by the existing lawsuit of the country, but for a definite period of time. It is not going to be for indefinite time. So, these kind of protections given by the states to the innovator, the person who creates it, is known as the property right, intellectual property right. So, how many different types of intellectual property we have? You see, it may be classified into different groups, but that classes may vary from country to country. Different countries may have different types of intellectual property, and some of you may have seen all those properties. Say for example, you may have heard about patents, which we are going to discuss by the mid of the lecture. Then trademarks, we have industrial design, plant varieties, copyright, geographical indicators, all these things comes under intellectual property, types of intellectual property. So, till now you may not find these things very interesting, but from this point onwards you will find this very interesting, because you have seen this half-eaten apple. Wherever you see this particular design, you never recognize it as a half-eaten apple. You always recognize it as Apple, the brand, isn't it? Whenever you see this alphabet C in this particular pattern, you will recognize it as Coca-Cola. This particular symbol represents Mercedes-Benz, SBI. You are not going to recognize it as a keyhole. You are going to recognize it as SBI. This is Hindi alphabet PA, but it represents PNB. This is Google, Audi, isn't it? So, what is trademark? Trademark is nothing but these are certain logos or marks which actually represents certain entity or organization. So, we call it trademark. Very recently, our Walkusi is known for its golden yarn, that is Muga. Very recently they have received trademark for their products. So whatever is produced in Hualkusi may be represented by this particular logo. I think 2 or 3 years ago they got this trademark. So if something is produced by Hualkusi, they may bear that kind of logos that represents Hualkusi. Why trademark is so important? I have never visited Starbucks, but many of you may have visited Starbucks. Why? The quality of the coffee is too good or what? Most of the time, we see it as a symbol of status, because I may not be, I may not afford 200 or 300 rupees for a cup of coffee, but there are people who would like to, have that kind of coffee or tea, and then they will show these things in the social media. So that is why, to popularize their brand, they used to put the name of the customers in the mug, and they started sharing this on Facebook and different networking sites, and that is how their industry started growing. And this is very familiar, I think. I have never seen any iPhone owner using their front camera to take their selfies. All the time they take their selfies in front of mirror. Why? And I have seen people keeping their mobile phone upside down on the desk to show the logo. Why? Because this is expensive. You can have a mobile phone at 10,000 rupees, but at the same time you are spending 50 or 60,000 most of the time. And even though the company is giving you a very good quality front camera, but you would like to have the photograph in front of mirror. Why? Just to show people the logo, this half-eaten apple. Isn't it? This is true. This is true. And the company also knows it. You see, he is taking the selfie in front of mirror only. You can see his image. Okay? But why? That is how the brand value increases. Apple, the brand value, you see, $612 billion. Microsoft, 162. Compare this Apple with Microsoft, and then you compare with the SBI, the biggest banking institution in India. It is only 5.8 billion. Compare it with Apple. This is the brand value, and that is why logos or all these trademarks are important. They become a status symbol nowadays, isn't it? Then comes trade secret. What is trade secret? You people are mostly from hotel management background, maybe from travel and tourism. So you may have seen KFC chicken, but at the same time you go to Digholi Pukhuri, you will be having same kind of chicken. They also calls it KFC. Okay, KFC like chicken. What is the difference? You see, when people goes to KFC, they take photographs again, they circulate, then I am having chicken in KFC, Kentucky Fried Chicken, isn't it? But if somebody is having it in Digholi Pukhuri, obviously they are not going to post it on Facebook, and I am having KFC like chicken in Digholi Pukhuri, isn't it? So KFC claims that they have a formulation and they are keeping it secret. Okay? Nobody knows what is the exact composition of the formulation. Okay? They are keeping it secret, and they are keeping it secret since last 50 years. Similarly, Coca-Cola, you see, the secret is 130 years old almost, more than 130 years old. Can you believe this? And Listerine, people have, I think most of you have used it also, Listerine. This antiseptic kind of thing that you can use for the gargling. 140 years old. So these things are known as trade secret. The validity of trade secret may be from 5 minutes to forever, but state knows the secret. That means the state means the patent office will be knowing the secret, what are the ingredients, they will be knowing. Okay? But other people may not be knowing this. But there are certain advantages and disadvantages of having trade secret. Reverse engineering can be done. During 1980s, to counter Coca-Cola, some Indian companies, they came up with this 77. The taste was almost the same, but nobody is there to tell you that whether the formulation is same like Coca-Cola or not. but reverse engineering can be done. But at the same time, the first point, brand value, trademark, you are having 777, but that cannot beat the brand value of Coca-Cola. People would like to have the same drink in a different bottle, and that is Coca-Cola's bottle. These things are interrelated. Similarly, Big Cola, I have tasted this and I found the taste is better than Coca-Cola. The taste is better than Coca-Cola, but even though it is better than Coca-Cola, but it cannot beat the brand value of Coca-Cola. That is the importance of brand value. That is how trade secret works. Then the next point comes, and that is copyright. What is copyright? Copyright is nothing but it is the expression of ideas in the form of audio visual things, in the form of text, in the form of algorithms, etc. These can be protected by copyright, and copyright is mostly denoted with this C, okay, within this circle. So whenever you open your laptop, you will see Microsoft is displayed, and you will see this thing, that this is copyright protected. Why not it is patented? Patent and copyright both are two different things. Patent is the most complex form of IPR. All these trademark, logos, everything comes under IPR, but patent I would say is the most difficult form of IPR that you will understand later on. So you have written a research paper, that is also copyright protected. You have authored a book, that is also copyright protected. You have created some certain algorithm, even the Microsoft, it works on algorithm only, that is copyright protected. Okay? So copyright means the expression of ideas in the form of audio visual form, or maybe in the form of text, lyrics, painting, etc. So these things can be protected by copyright. Then comes design registration. You may have seen Ola Scooty, the electric one. So that design is also protected. Even a hammer can be protected. Even the design of the Coca-Cola bottle is also protected. You won't see same kind of bottle selling by any other company, or else you are going to claim for compensation. Even the Lay's, you have seen the chips, no? That is having some ridges, linings, and these are uniform, and these are all copyright protected or design registered. Okay? So nobody else in this world can make the similar kind of things. These are all protected. So for every creation you have the limitation. So for this you have the limitation for 10 years, which can be extended for another 5 years. Okay? But again, these laws varies from country to country. Then the next point, that is geographical indicator. What is geographical indicator? Geography, any place in the map. So thing is that if you are talking about certain products, and if it represents a particular locality or a geographical particular location, then we call it geographical indicator. Say for example, whenever you see gamusa anywhere in the world, suppose you are watching a football match which is taking place in Kuwait, and somebody is wearing this gamusa, you will see that this person is maybe from Assam. So it represents Assam, geographical indicator. Similarly, very recently Kazi Nemu, it has got GI tag, geographical indicator, because it represents again Assam. Black rice represents Manipur. This Assamese dhul, you may have seen this kind of drum in other parts of the country also, but the design is different. Okay? So Assamese bihu dhul is also having GI tag. I think just 2 years ago they got this. Even the japi also got GI tag. Okay? This is kumal saul. Kumal saul, have you seen? Buka saul or kumal saul. It doesn't require conventional cooking process. Just you need to soak it in warm water, lukewarm water, and then it will become soft. You can add some amount of curd and jaggery, and then you can have it. Okay? So this thing has also received geographical indicator. Very recently, Tezpur Lychee also received geographical indicator, and there are so many products from Assam, they have received geographical indicator. and this one is very famous. Have you ever visited Tirupati? I am not talking about the one which is located the other side of the university. Tirupati means that is in Andhra Pradesh. I visited there. So once you visit, you will have this prasad, that laddu, and it has got a very typical taste. And without using any preservative, you can keep it for I think 2-3 months easily, very easily. And the taste is really good. They also applied for geographical indicator and they have received this GI tag for this laddu. So this particular laddu has also received geographical indicator. Why am I citing so many examples of food or food products? Because only for you guys, because you people are from travel and tourism, and I hope you will be also coming up with certain products after completing this session. So that is the sole objective of this entire presentation. Then comes Plant Breeders Act. That is also a kind of intellectual property. You will see certain farmers who conventionally crossbreed certain plants to get better variety. Sometimes they do it with rice. They take different varieties of rice, they crossbreed it to get better variety. So these things can also be protected, and this is protected by the Plant Breeders Act in India, and other countries also may have similar kind of things to protect their ideas. Then the most complex one, patents. But before understanding patent, you need to understand the difference between discovery and invention. Suppose you have discovered a star for the first time, you have given a name also with your own name, but that is discovery. Columbus discovered America. It was already there on the globe, but he was the one who discovered it for the first time. Similarly, if you have identified a new star and given it a name, that is also a kind of discovery. It's not invention. Invention is which is not reported before in the entire world, and you are the first one to make this. That is invention. So that is the difference between invention and discovery. Discovery means you dropped your pen somewhere in this room, nobody could find it, and there is a student who could find it out. So it is the discovery of the pen. That is not the invention of the pen. Okay? So there is a difference between discovery and invention. Now why patenting is important and why it is the most complex form of IPR? See, knowledge creation and ownership of the knowledge are two different things. You wrote a research paper, you wrote a book, so you have created certain knowledge, but that knowledge can be utilized by somebody else also. You are not the owner of the knowledge. You have created it, you have authored a book, but your students can refer to that book. So you have authored the book, but you are not the owner of the book, owner of that knowledge. Okay? And that is the difference between patenting and having copyright. Copyright will give you the recognition for creating the knowledge, but it is not going to give you the ownership of the knowledge. Patenting means without taking your prior permission, nobody else in this world can use it. That is the beauty of patenting something. So that will give you ownership. So now, see, can you recognize him? Newton, he discovered gravity. Could he get a patent on gravity? Yes or no? No, because he discovered gravity. That is not invention. To show you the difference between invention and discovery, I am citing this example. Newton discovered gravity, but it was not his invention, so he cannot have a patent on this. Okay? So now to get a patent, whatever things you produce, it must fulfill, not should fulfill, it must fulfill all these 5 criteria. Sometime you may come up with something which may fulfill 1 or 2 of the criteria, or maybe 4 of the criteria, but the 5th one is not fulfilling, then you are not going to get a patent granted. So to get a patent granted, your invention should fulfill all these 5 criteria: must, novelty, non-obvious, reproducibility, patentability, and commercial application. I will discuss on it. one by one. So what is novelty? Novelty is if it is not reported before and you are the only one who have done it for the first time in the entire world, not specific to a particular region. It has to be a novel in the entire world. Nobody else in the world may have done it. If somebody has done it, if it is reported, then that breaks the novelty. Even if you are coming up with a new product and if you are displaying it in an exhibition, that breaks the novelty. If you are presenting in a conference, you may get an award, you may have a good paper published also, but that is not going to give you patent on this. Okay? So first thing is that to preserve the novelty, you are not supposed to disclose anything before you file a patent. First you file a patent, then you can disclose, no issues. So you can understand this thing with this example. Do you know Donald Duck? It's a Disney character. So there's a inventor, his name was Carl Croyer. He invented something to make the sunken ships float. So this is a sunken ship. He was proposing to put a thread on it, and then he will be putting some balloons inside. It will swell up and then it will start floating. See, the ship is now floating. So he got the patent granted. His patent was granted in so many countries. Germany, it was granted. In UK also it was granted. Okay? Patent was granted. Then he filed it in Denmark. When he filed it in Denmark, the examiner could find out this cartoon which was published in the year 1949. It was published in the year 1949. And in this cartoon, Donald Duck along with his nephews, they were trying to float a sunken ship by using similar kind of process, just by putting some balls. So this is known as prior art. Prior art means this concept was already there, and the examiner could find it out from this magazine published in the year 1949, and the patent was rejected. And eventually it was rejected in UK, it was rejected in Germany also. So your duty is to file a patent, but the patent examiner's duty is to reject your patent, for which they are getting the salary. Their job is to reject your patent. They will find something to reject your patent. Okay? So you have to maintain the novelty. If it is novel, then only you are supposed to get a patent. Okay? So that is why I am telling you repeatedly that if you are coming up with something new, then you should not display all these things in front of public. Once it goes to the public domain, it goes to Facebook, it goes to Instagram, you are going to lose the novelty, and the examiner will find it out whether this is novel or not. Okay? Okay. Then comes non-obvious. I think you are now thorough with novelty. What is novelty? ठीक है? सबको समझ में आया novelty? ठीक है? So then is non-obvious. Non-obvious. What is that? You have a chair, you just change the shape. This is obvious. You change it into this also. So should I get a patent on this? No. This is obvious change. If it is obvious, then you are not going to get a patent. You have to make something which is non-obvious. See, this massaging chair is non-obvious. Why? Here you are changing the design, not the functionality of the product. But the massaging chair has got a different function. In this case, you can have a massage also by using electricity. It is just not only meant for sitting. You can sit there at the same time, you can get the massage also. So that is why it can be patented. Okay? Then the next example, you know this fellow? Stephen Hawking, known physicist. Okay? He was a known physicist, and he was suffering from a disease called motor neuron disease. So he could only 1 or 2 fingers in his, I think, right or left hand, I forgot. Okay? Then there was an inventor who invented this chair for him, so that he can speak, he can write books just by seeing the display, which is invented by Lenovo. Lenovo is a Chinese brand. Okay? They invented this chair and all the features are there. It can travel 20 miles, 20 miles at 8 mile per hour speed just in on one charge only. Okay? So all these features are showing there. So you see, this is non-obvious. So this chair was patented. Okay? So this is a normal chair with obvious changes that cannot be patented, but you change the functionality of something that can be patented. Okay? The next point is reproducibility. What is reproducibility? Reproducibility means if you are filing a patent, you need to mention all the points by following which a person skilled in the art can get the same result. If you are claiming that you mix A and B, then you boil with C and then you add D this much amount and you will be getting the product Z, and after going through all this protocol, if I am doing it in my lab and I am not getting the same product, then you are not going to get a patent. If you want this patent to be granted, then you have to mention all the points in such a way so that a person skilled in the art can get the same result wherever he does it anywhere in this world. So it doesn't matter, but he should get the same result. If he is not getting the same result, then it is not reproducible and you are not going to get a patent granted. So that is reproducibility. And then you have patentability. Patentability is the law of the country. Now whatever you patent you file, it has to be granted by the patent office based on the existing laws, patent laws in that country. Okay? So different countries may have different sorts of law. Sometimes they may favor granting a patent, but sometimes they may not favor the application due to certain limitations. Say for example, if your patent is a threat to public property, you cannot file a patent. If your application is a threat to national security also, then also you cannot file a patent. There are so many. If it is biohazard, then sometime you may not get a patent granted. So in this diagram I am trying to show you, suppose I have invented a magnet that can pull all the money that you have in your wallets. It may be non-obvious, it may be novel, it may be reproducible, okay? It may fulfill all the criteria, whatever has been discussed, but it is not patentable. Why? Because it is, you see, it's a threat to public property. If I have that magnet, obviously it is going to pull all the money whatever you have in your wallet. So it is not going to get a patent granted. Okay? But at the same time, you can see that more than 6,000 gun related patents were granted since 1977. So how do they get the patent? So you have to understand one thing. Whenever you file a patent, you have to justify the things using the laws and regulations whatever is followed in that particular country. Say for example, if I want to get a patent granted on a firearm, I am not going to display it as a threat to the public property. I have to write it in such a way so that that particular product is going to provide security to the country. If you are writing in that manner, then you can get a patent granted. So getting a patent is not about what you have done in the lab. It is also the way you present it. If you are presenting it by fulfilling all the criteria given by that particular patent law of that particular country, then you will get a patent. Otherwise, the patent will be rejected. So there are certain challenges related to patenting something. Say for example, if it is biological substance, then you have to be careful. Why? Because sometime you may come up with a medicine which may involve the use of endangered plant species. Suppose there is a plant species which is critically endangered, but it is curing cancer. Now you are coming up with a patent, then you have to be very, very careful. Why? Because after once you get a patent, that means government is giving you the right to utilize all these plants to produce that medicine, but at the same time it will hamper the biodiversity. So in that case, whenever you are working with biological substances, you have to take permission from National Biodiversity Agency, NBA. Once you get NBA's approval, then only you can go for filing a patent. Means you can file it initially, but in later stages you have to get a permission from NBA. Without getting their permission, you are not going to get a patent granted. That is the main issue with biological things. Then traditional methods and knowledge. There are so many people, say for example, I have a patent on rice beer, and you people may be knowing that rice people is is produced by so many local tribes in Northeast. It's common. And if I am coming up with a rice beer, and if I am following their method of producing rice beer, then once I get a patent granted, that means these communities are not authorized to make rice beer. I can sue them to the court. So that is the thing. But in my case, I did not follow their methodology. My methodologies were totally different than that of the commonly used methods. That is why my patent was granted. Then on gene sequences, you people are not from biotechnology or maybe from allied backgrounds, so obviously you won't be understanding that part. So here I am showing you a few examples of patented food products, keeping those things in your mind that you people are from this background only. So this is not in a very presentable form, but you can see dried fish, for which I got a patent granted. I have a patent on this, and I was being awarded by state government also for this invention. So these dry fish doesn't require conventional cooking. You just take some amount of ketchup and you can eat it without cooking. And even though this is dry fish, it doesn't have any obnoxious smell. And you soak it in lukewarm water, again it will gain the weight. Then you can cook it also, almost in a conventional way. So that is the thing. Then this is rice beer. Normally, local communities, they produce rice beer and it looks like this only, whitish, and doesn't have good color or transparency. So we made rice beer in this way and in a different way, and the product is just like any other beer, transparent beer. So for that also we got a patent granted. So here you can see certain examples of patents on food product. Here somebody is getting a patent granted on juice. Then this is on, I think, biscuits. Then on pizza. Then on, I think this is on dried meat. This is a kind of pizza, different kind of pizza. They are getting a US patent on it. Here you can see a sandwich loaf. I have never tested it, but they are also getting a patent. You can see how they have made all these things by using different instruments. They are showing it in a diagram. Here, this is pet food, patented, and this is a pasta sheet that is also patented in United States. Then you can see hot dog rolls, how they have made it. Based on that also they got a patent granted. Then this is also kind of hot dog roll. For that also they received a patent. So these are some of the examples from your own field. So you can also come up with certain products in future, and you can file a patent in India. And I am sure maybe within next 6 months or maybe in 1 year, you will be coming up with some novel products. You search it on internet, whether these products are already existing or not. And if you can find a novel angle, then definitely you can file a patent. You see, for a single mobile phone, we have more than 6,000 patents. Patenting mobile phone doesn't mean that you are going to get a patent for the entire phone. Patenting a laptop doesn't mean that the company is having patent on the entire laptop. You open it, you will see motherboard is there, different chipsets are there, and they have their own patents. Okay? And these patents are owned by different companies. So if you are coming up with a product, it doesn't mean that you are going to get a patent on the entire product. Maybe there may be a new novel step in that particular product while making it, and for that particular step you are going to get a patent granted. Okay? So patenting is not impossible. So you can definitely come up with some new ideas. So how to file a patent in India? You see, zone wise, we have 4 patent offices. If you are in Northeast, including this Sikkim and West Bengal, up to this much, Orissa, Jharkhand and all, for them we have a patent office in Kolkata. For Northern India, we have a patent office in Delhi. Western part of the India, we have patent office in Mumbai. Then for South India, we have patent office in Chennai. Okay? So if we are from Northeast, so we can approach to Kolkata patent office. So what is the procedure? It's a very lengthy procedure. So I'm not going to explain all the steps, but you need to understand a few steps. First, you need to file a patent, and the date on which you are filing a patent becomes your priority date of filing. That means your patent has got, if it is granted with a patent, it has got 20 years validity from the date of filing. Suppose I am filing it today and after 4 years my patent is granted. That means the validity will be counted from today's date only, the date of filing. Okay? So the validity for the patent in India is 20 years. Then once you file a patent, you have to make it public. Why? So that people read it and they can comment it if you are stealing someone else's methodology or procedure. Okay? So you need to publish your patent. So you are publishing doesn't mean that you are going to publish it in a research paper. So there is an official journal of the patent office. Just by paying some fees, you can publish it early. Okay? Once you file it, then it will be published and it will be there in the public domain. And people like us will be looking for patents. If we come across of these things, then if we feel that our invention is stolen by someone else, then we can claim it. Okay? So for that there will be different stages. So we'll discuss about it later on. Then once it is filed, then you have to request for examination. I told you the duty of the examiner is to reject the patent. So they will find out the prior art. Prior art is nothing but, you may have heard about literature survey. So if you are doing research, we call it literature survey. You go to library, you go to internet, then you search for that kind of papers to consult on consult them. So in case of patent, we call it prior art search. If related things means these things are already there in the internet, you can find it out. Then after examination, they will your examiner will give you chance that we have objection on these things. Can you solve it? If you can solve it, your patent will be granted. If it is not solved, then patent is rejected. So that is how it works. And then I have seen so many people filing patent outside India. For them, I would like to tell you that first, as a citizen of India, you have to file patent in India only first. Now it is totally up to you whether you want this patent to be examined in India or not. Filing doesn't mean that your patent will be examined in India. Suppose you want to have an US patent, but you don't like to get the patent granted in India. Then you file it in India. Then take permission from the Indian Patent Office and then you file PCT. PCT is Patent Cooperation Treaty. Under PCT, we have more than 140 countries who will under which you can file patent. Okay, so for example, under these 140 countries, we have USA, Denmark, Netherlands and all. Then you can, after filing PCT, you can file the patent in USA, UK, all these countries. Okay? So I'll show you one patent document. If you download it in internet, you will see the patent number and date of grant that will be displayed. This is typical US patent. It is displayed in the top. Then patent application number and filing number would be displayed up here. Okay? So it was filed in the year 2002, December 23, and it was granted, you see, August 2008. It took 6 years to get the patent granted. Just an example. Nowadays things become quick. So maybe in USA within 1 or 2 years the patents are granted. Okay? And this is called abstract. Abstract means the summary of the invention, whatever you have done. Okay? So these are all technical things. then how you search all these things on internet. Even you can follow all these techniques to search for your research papers on internet also. Say for example, you need research papers which talks about cats and dogs. Okay? You write both the items and just put an AND, A-N-D in between. So that will show only those papers which are talking about cats and dogs together. Okay? So that techniques can be followed for searching of research papers also, not only for patents. So you need two items. Suppose you need item A and item B, and you want both the items to be displayed in a single paper. Then you have to write A and B. Suppose you need both the papers. You need some papers with mentioning the item, about item A and item B and item A and B all together. We call it OR. You write cats or dogs. That means you will be getting all the research papers on cats, all the research paper on dogs, and cats and dogs all together. But now you need only one kind of research paper which talks about only dogs, not about cats. Then you write cats, not dogs. So whatever research paper you will be getting, that will show only cats, not any research paper with dogs. Okay? So that is how you can do survey. So these are patent search engine. Whenever you search something, you spontaneously open Google and then you do it. Okay? But putting something on the Google doesn't mean that you will be getting all the information, because for that you need to do some deep search. Say for example, if you are talking about patents, most of the patents are not displayed spontaneously on Google. So for that, patent databases are there. Say for example, this one is European Patent Office database. You have to Google it, European Patent Office. Then you will be getting a search window. Then you put your query, then only you will be getting the patents available with European Patent Office. So that is how it is displayed. Okay? Say if you are writing sanitary pad, you will be getting all these information, all these papers, all these patents which talks about sanitary pads. Then comes the second database, that is USPTO, United States Patent and Trademark Office. You Google it, then you go to search for patents. Now after clicking on that, the new window will come. Now patent public search, click on patent public search, put the topic, then you will be getting this kind of patents, already published patents in the database. So these are examples of patents only. I don't want to make the presentation very boring, so I am skipping all these things. So I said that a single mobile phone may have thousands of patents. So if you are coming up with some new product which is associated with a mobile phone, and if you want to get a patent granted, how will you do that? When you draft a patent, there is a small part in the patent application. That part is the most important part. We call it claim. Claim means that defines the periphery of your patent. That defines the periphery of your patent. That means you have invented something, but you are claiming your patent on a particular point only. So the claim actually denotes that particular point. And whenever you draft a claim, you have to be very, very careful. Once you put a full stop, that claim is complete. So claims may go pages and pages without putting a full stop. Sometime you will be using comma, sometime you will be using semicolon and all those things. And once you put a full stop, that means your claim is finished. So you may have so many claims, 10, 12 and so on. So that will define the periphery. Then these are patent citation. Okay, these are certain weird kind of patents. So there was an inventor who came up with this patent in 1876, a device to protect his mustache. Okay, so it was granted with a patent in 1876. Imagine. Then people are coming up with this device. I think that would be beneficial for all the students. If you are setting the alarm at 6 o'clock, so there are so many bottles kept above his head filled with water. So it will start sprinkling water on the face once the once you put the alarm on. Okay, so I think they got a patent in 1882. Then based on whatever I taught you, whatever we discussed, I am just giving you one example. So this is one ring. You may have seen this kind of ring, na? So there is a closing gate also, there is a spring. So it was been granted with a patent. And many of you may have traveled through airlines, may have used this seat belt, and that seat belt is also patented. That one is also patented product. Okay? So somebody is having this patent, okay? And you are inventing this one. So will you get a patent on this? This patent is already granted and you are coming up with this design. Will you get a patent on this? How many of you says no, or how many of you says yes? Yes, how many? Just raise your hands. No? I say yes, there is only one. Yes. And no? सब लोग no ही है, ठीक है. Somebody said yes. Why do you think that he should get a patent? You should get a patent on this. Why? See, this is a auto closing gate where they have used a spring. ठीक है? But sometimes accidentally it may also be opened, no? Automatically. But here you are using a pivoting ring. So there is more safety. So for this point you can get a patent granted. ठीक है? So that is the difference. You see, both are almost the same. Function is almost the same, but it gives you better safety. ठीक है? Because you are going to close it na properly. That is why you can have a patent granted on this thing. So there are so many patent forms. Actually there are, I think, 24 or 36 forms, I forgot. But not all these forms are equally important. So if you are filing a patent, you need to download form 1, 2, 3, then form 5, 9, 18, 13, all those things. Okay? Then you can go for filing a patent. These are all the examples of the forms that you will see in the internet. So you just directly go to the patent office website, then the forms and downloads are there. You can download all these forms whenever you come up with new idea. And the filing fee is only 1600 rupees. You can file a patent just in 1600 rupees, but in later stages obviously it involves money. Okay? And drafting part is difficult. So whenever you draft a patent, you need to have some advices from your seniors, maybe from teachers, or you can directly consult with me also. Whatever can be possible, I will definitely do for you. So these are the forms and formats that you will see on the internet. So for your understanding, I am showing you all these things. How it looks once you get once the patent is granted, you will see. This is my own example because this is a patent granted to me. So it has got, you see, patentee means the applicant. The applicant name is Professor Pradeep Kumar Gogoi. Then name the inventors. So Professor Pradeep Kumar Gogoi and Debajit Borah. So both were the inventors. Okay? So this is the certificate. Once the patent is granted, you will be getting this kind of certificate. Okay? And validity of this entire thing is 20 years from the date of filing. So date of filing is already mentioned 10/4/2015, and from that date onwards, we have 20 years of validity. Okay? So thank you so much to all the faculty members for giving me this opportunity, and students also for patient listening, because I know the topic is very boring, and I tried my best to cite some examples from your own field so that you can correlate. So if you have any questions regarding this patenting and all, you can ask me. Any questions?
Sir, for sharing his insightful speech with us. Your words have resonated the audience, and we appreciate the time and effort you put into preparing such a thought-provoking presentation. Your expertise and perspective have enriched our understanding of the topic. We are grateful for your contribution. Ladies and gentlemen, I would like to announce that following the speaker's presentation, we will now be transitioning into a Q&A session. I kindly invite you to share your questions and thoughts by raising your hand. Our speaker will be delighted to provide further insights and address any inquiries you may have.
without taking permission from your side. So that can be done. And second thing is that the way of creating the product, the procedure. Actually in India, it is easier to get a patent granted on the methodology, the what you call procedure. Okay? So if you are doing, if you know that this much ratio of this thing has to be mixed with this thing and the product is this thing, and if certain non-obvious steps are there, novel and non-obvious steps are there. Say for example, in our case, suppose we want to preserve something for a longer duration of time, it is liquid, we put nitrogen and all those things to make it, sterile, all those things. So these are certain, examples of non-obvious steps. Normally you can use some chemicals also. Suppose there is a beverage that you have made, and if you keep it for 1 year under normal temperature, it gives certain precipitation, which will hamper the market value of the product. And if you are adding certain chemical, and it prevents the formation of precipitation. So that can, the entire process with mentioning all these steps can be patented. So patenting is possible. You have seen that so many, they are getting patent granted on pizzas and hot dogs, all those things. So why can't we have a patent on the process of making a particular mocktail? So it is feasible, it is doable. Yes. See, patenting is not a very straightforward thing that you will be drafting something and the patent will be granted. So you see, legally, if you do it by yourself, then it is not that expensive, because filing fees is only 1600 something. So that is affordable. Then after filing, you need to publish it. And if you are publishing in, I think the cost is around 4,000. Previously it was I think 8,000 rupees. Then you will be going for examination. You have to request for examination. Otherwise it will be kept in the patent office without examining. And after 4 years, it will be discarded. So you have to request them for examination. For examination also you need to pay, I think, around 10,000 rupees. These are all, additional charges. Filing 1600, early publication 4,000, examination I think maybe more than 10,000, and so on. So once you get the patent granted also, annually you need to pay money to maintain the patent. For 20 years, exponentially it will increase annually. Why? Because if you are having a patent, that means the sole motive of having a patent is what? To commercialize it. If you are not commercializing it, if you are not earning money, then having a patent on a particular product is actually worthless. And then you have to, maintain this thing, for 20 years. Otherwise, after a couple of years, if you won't pay the money, it will be abandoned. 20-25,000 if you are not consulting any patent attorney. If you are taking any help from an attorney, I don't know how much they will be charging. Recently we filed a patent, but we were lucky enough to have our own projects. From that project head only we met all those charges, and it was around 56,500 overall. But nowadays government is also giving certain incentives. So for example, if you are coming up with all those things, there are funding agency. You share your idea with those registered patent attorneys through those government agencies. Then free of cost you may have a patent. Okay, but